And modern thinking over now a long time, several centuries, has tried to look at the world and understand the world based only on what made the thing and what is it made of. But if we don't accept that things are something in their essence, something unchangeable, something immutable, in our case, man and woman is part of what you are in your formal causality, in your essence, and what you're made for, right? Men and women, persons, we are made for specific things. If we jettison those and we kind of talk on materialist grounds, as if there's no life doesn't have a purpose, man doesn't have a purpose, woman doesn't have a purpose, we're just made of stuff and we're here and that's it. We're never actually going to solve these problems of what is a boy, what is a girl, how do we do all these, how do we deal with these trans issues, how do we deal with the differences between the sexes. Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
At least for today. Sorry. I know that I would just note here that I did bid Joseph farewell on the last episode, but then we had the opportunity to record this one on Joseph's very last day with Napa Legal. So thank you, Joseph, for bearing with me and doing one more.
Yeah, very happy to. I figure since it's official my last one, I can unleash every hot take I've built up in the last 2 years and not have to worry about it.
Well, we have a couple of good cases to do that. So first of all, we thank you for joining us, our listeners, for this episode of the Napa Legal Podcast. As always, we ask that if you do enjoy the content that we're putting out, we appreciate it if you like the podcast, subscribe to our channel from YouTube, Spotify, or wherever you happen to be listening. So we're going to cover two cases today. We'll probably be a little bit briefer, but they're important. First of all, we're going to cover the Supreme Court's recent decision in the Louisiana versus FDA case that I believe we've covered now in 3 successive episodes of the podcast due to ongoing constant updates. And then we will talk about a case going up to the 10th Circuit that continues to grapple with some of the grave practical problems caused by gender ideology. So let's start with the FDA, Louisiana versus FDA case. Again, if you've been listening to us, you've probably been following this case. But for very brief background, this is based on the 2023 rule from the FDA that was obviously meant to increase access to abortion after Roe versus Wade was overturned and Casey were overturned by Dobbs. So the FDA in 2023 dropped the in-person requirement for a doctor's visit before a woman could obtain mifepristone, the abortion pill. The practical effect is that decision nullifies many pro-life states' bans on abortion, since mifepristone is the most commonly used chemical abortion drug in the country, and could now be readily shipped across state lines with pretty much no oversight or recourse from states like Louisiana. So Louisiana sued the FDA, claimed that the FDA's 2023 decision violated the Administrative Procedure Act, overrode state sovereignty. There are several arguments. It's largely a standing argument, actually, whether Louisiana has standing to sue, given the 2024 case also on the abortion pill um, that denied standing for drug companies in a similar kind of challenge. So, while Louisiana won this argument at the Fifth Circuit, we discussed this at length in the last couple of episodes. The U.S. Supreme Court placed a stay that was a temporary stay originally on the ruling. So, if you'll remember, the Supreme Court issued a temporary administrative stay and said it expires, I think it was a week. There was an opportunity for the drug companies that had intervened, drug companies that sell mifepristone, to send replies to the Supreme Court. That was supposed to expire on the 11th of May. Then it was extended to the 14th of May. And then we're recording on the 15th. So on the 14th, just after 5 p.m., the Supreme Court issued a disappointing and sparse order, leaving the 2023 rule intact and effectively allowing mifepristone to be shipped without the doctor's visit while the lawsuits in the lower courts proceed on the merits. So disappointing is an understatement. I know Joseph wants to focus on Justice Alito's dissent, which was the more lengthy one. So I'm going to focus on a couple of practical points, and I'm also going to note Justice Thomas's brief but quite powerful dissenting opinion. So first thing, I have to say, I'm concerned by the lack of an actual opinion by the court here, right? This is a big deal. There were a lot of complicated questions of who has standing on this. Is Louisiana's sovereignty and their criminal code being undermined sufficient to grant them standing to sue? Were the financial harms caused to Louisiana, right? That they had to like pay out Medicare and Medicaid dollars in this case, to women who were hurt by mifepristone. What is their standing? Are they likely to prevail on the merits for this challenge to the 2023 law? We don't really know because all we have from the court here is a short paragraph granting the drug company's request for a stay, which eliminates the Fifth Circuit's stay and keeps the 2023 rule in place. So we don't really know what the merits of the ruling are. We just have the stay and then two dissents. So I think it's unfortunate. Uh, that's putting it lightly. The Fifth Circuit opinion I thought was well reasoned, holding particularly the FDA rule undermines Louisiana's sovereignty, right? They have a criminal code. It bans abortion, including abortion by chemical means, drugs like mifepristone. That law is effectively meaningless with this rule intact, right? The drug manufacturers, in their response here, focused on Louisiana's argument about financial harm, saying that that's not enough to grant standing. But I think the harm to state sovereignty is the much stronger argument for standing here, not the financial harm. In the argument at the Fifth Circuit, I thought the financial harm argument from Louisiana was kind of like not a throwaway, but it was definitely the secondary argument. And yet that's what the drug companies focused on, that being not sufficient. So there was a little bit of, I think, like straw manning the argument. I think Louisiana's argument was much stronger than the drug companies said. But again, we don't really know what SCOTUS thinks of these various arguments. All we know is that we have the Fifth Circuit stay now blocked, and mifepristone can continue to flood pro-life states through the mail. Disappointing to say the least. Also disappointed that there were only two dissents, um, which means that there were, seven justices in favor of staying the Fifth Circuit block on mifepristone being mailed. So we'll leave that at that. We'll see if this comes back up on the merits to the Supreme Court or what's going to happen from here. Um, I also just want to note before I get briefly into Justice Thomas's dissent, a practical point. The ultimate answer to this conflict should be for the FDA itself to rescind the 2023 law and just restore the in-person doctor visit requirement, at the very least, if not weigh in a little more heavily into how dangerous mifepristone is as an approved drug in the first place. Not least of which because it kills unborn babies, but also because of the harm it does to women who take it. So with the mounting evidence of how dangerous mifepristone can be, I think it should be done quickly at a minimum to restore some guardrails, in-person doctor visit, monitoring of side effects, and so on that were dropped by the 2023 rule. Um, but the reality is, when this lawsuit came up, Louisiana versus FDA, the FDA kind of asked that it be stopped so they could review their 2023 rule. But that review is stalled. Nothing's been done, um, at least nothing public. And I think this whole saga within the FDA and why they haven't moved on the review of this rule is made a little more interesting by the fact that Dr. Marty Makary, who was the head of the FDA until last week, just resigned. Not clear if it has to do with this case or what is going on. There have been a lot of murmurings in DC that the former FDA head, Dr. Makary, was not a friend of the pro life movement and had been maybe involved in the slow walking of this review. I obviously can't confirm that. These are just rumors. But the shakeup at FDA does present an opportunity for a kind of reset on the conversation surrounding this 2023 rule. Um, I'll note that the current acting head now of the FDA, who was the deputy, Kyle Diamantis, has also caused some controversy among pro-life circles. Although we don't know the extent of it, it's a little bit controversial. Um, there's documentation that when he was a young lawyer, he was on a team for a big law firm that was representing Planned Parenthood in some kind of property dispute. So obviously, the pro-life movement is very concerned that he's formerly represented Planned Parenthood. Although I read into it just a little bit, and it looks like he was a junior associate, not like the head on the case, and that he eventually pulled himself off of that case for personal reasons. So I don't know. He claims to be a pro-life, pro-family um, lawyer and political appointee. So we don't know what he will do here. We also don't know if he's going to be the long-term head of the FDA. He's the acting head. The Trump administration might put somebody else in there. But regardless, under Dr. Marty Makary, the review was not going anywhere, clearly. So hopeful that with the shakeup, we might see a more pro-life FDA head that could actually move the review of the rule ahead and make this a moot point rather than going up and down and back and forth in all the courts. It would be good to just have this problematic rule removed by the FDA. It seems like the obvious move given how controversial and problematic and dangerous this drug is. One more point. Justice Thomas, so as Justice Thomas is wont to do, writes a very short dissent that minces no words. And I wanted to give some brief time to this before Joseph goes into Justice Alito's longer. I think it's about 5 pages, his dissent, but Justice Thomas's is a few paragraphs. He says that he dissents with Justice Alito, but writes separately to explain that besides Louisiana's state laws being undermined by this rule, there's a federal law, the Comstock Act, that explicitly bans using the mails, right, mail, to ship any drug for producing abortion, period. That's in the U.S. Code. And Justice Thomas goes on, there's a neighboring provision that makes it a felony to use any express company or other common carrier or interactive computer service to ship any drug designed, adapted, or intended for producing abortion. And so Justice Thomas goes on, applicants, the two drug companies, ship mifepristone to certified pharmacies, which in turn must ship mifepristone using a shipping service to users. So the process approved by the FDA's 2023 rule, right, dispensing with the in-person requirement of a doctor's visit and a prescription and allowing this to be done through the mail, I think clearly violates the Comstock Act, which is a federal criminal law. So Justice Thomas concludes his dissent with powerful words. And I'll just read here. Applicants, the two drug companies, are not entitled to a stay of an adverse court order based on lost profits from their criminal enterprise. They cannot, in any legally relevant sense, be irreparably harmed by a court order that makes it more difficult for them to commit crimes. End quote. It sounds, hard and spicy, but he's right. I mean, it is a federal criminal act to ship abortion drugs through the mail. It is a violation of Louisiana's state criminal code to bring abortion pills into the state of Louisiana. The business of these two interveners, these drug companies, is to do just that, right? They're challenging this law because it hurts their business, but their business is shipping mifepristone via this 2023 law into a state that bans it in violation of both state and federal criminal law. So it's ironic and horrible that they're saying, "Well, we're being irreparably harmed by the court's order that makes it more difficult for us to violate the law, right? To ship drugs that are illegal under federal and state law through the mail." It's just like it's hard to fathom that this was the cause for the Fifth Circuit's stay being blocked. And essentially, I think Justice Thomas's ruling gets to the heart of Justice Duncan's opinion in the Fifth Circuit. Right, the state of Louisiana and the people of Louisiana are being harmed by having criminal laws against abortion rendered meaningless by this FDA rule. So I could go on, but I, as always, or as usual, am a big fan of Justice Thomas getting to the heart of the matter and pulling no punches and expressing what exactly is going on here.
Yeah, like you mentioned, Justice Thomas got straight to the issue, and Alito did something pretty similar in his dissent. He starts by explaining about how this is basically a continued effort to cut back on the court's decision in Dobbs to return abortion to the states. And I do want to highlight the one particular point Justice Alito, and he did talk a lot about, yeah, the state sovereignty issue that Judge Duncan had written about. But the one point that I really wanted to highlight is that he noted that the FDA actually never enforced the in-person requirements. And he did this to further build upon that argument that there's no irreparable harm. He's basically saying that even with the in-person requirements being in place, the abortion pill manufacturers wouldn't really be affected by them. So regardless, there's no actual harm being imposed upon these groups. And legally, that is important. But I think the more important thing is that this gets to a cultural point. And this shows that the pro-life movement has a lot of work to do beyond just getting the actual laws right. Because even if the court were to overturn and get rid of the FDA's decision to drop the requirements, it might just not be enforced. And legally, I do think there are problems with the Supreme Court's decision here. I think Justice Thomas's dissent really explains them. But arguably, the bigger issue, at least through my eyes, is this point that Justice Alito brought up. Even with an administration that's generally better on life issues than the previous one, pro-life leaders need to keep pushing for cultural respect of unborn life. any legal victory is at least somewhat empty unless we have a deeper societal culture and understanding that sees unborn children as valuable. We need groups that get in the legal trenches and try to win these legal battles. These are crucial and necessary and important. But we also desperately need people in the streets that are trying to move public opinion and adds a little bit of efficaciousness to these legal victories.
Yeah, that's right. I'll just say the it's a both and strategy for sure, right? You have these like, is politics downstream of culture? Is the law a teacher or just a reaction to public, sentiment? And obviously, you need both here, right? Like, it's very hard to get anything done politically or legally if the culture has become so bad that most people are in favor of abortion drugs. But it's also, I think, inappropriate and excusable because of the government's duty to promote the common good to allow, right, like pills mailed through across state lines to kill unborn babies because the people want it, right? The people want plenty of things that are vicious and are bad for them. So, yes, you're right. I mean, we need the work on the ground to change hearts and minds. But in the meantime, we have to do whatever is politically and legally feasible, to move the needle as well.
Yeah, absolutely agree. Both and is a great way to try to protect unborn life as much as possible. So, with that, we'll move into our second and final update for this week's episode, where the 10th Circuit will decide if children can be forced to share beds and other intimate spaces with members of the opposite sex in public school trips. So, the facts in this case are pretty astounding. There's a group of parents in Colorado that brought this suit. I'm surprised Colorado is implicated in another religious liberty claim. So there's a family called the Wales family who sent their 11-year-old daughter on this long anticipated overnight public school trip. They had been fundraising for it. It was very expensive, and the girl was very excited. It was this really big kind of um, big family moment for them and for really all the kids that go on this trip. And the public school stated that sleeping arrangements on this overnight trip and any other overnight trip run by the school are separated based on floors. So boys sleep on one floor, girls sleep on another floor. Everything's divided up by sex as it should be. However, parents are never actually told that the school defines sex as being based on a student's self-avowed gender identity. So as a result, this family was shocked when their daughter was told that she had to share a bed with a male student who identifies as a female. And she's not the only person that has actually had this happen to them. There's several other families bringing this claim. There's one young boy in Colorado or a young boy in the same school district who was put in a cabin on another kind of overnight school thing. And again, the cabins were segregated based on sex. One was a boys' cabin, one was the girls'. But in the boys' cabin, there was an 18-year-old counselor who just days before this trip began identifying as a male. And this counselor was assigned to making sure the boys didn't use too much hot water during the showers. So she was actually stationed in the bathrooms while these kids are taking showers. And the boys were saying, we don't want to change in front of anybody because we're embarrassed about it. There's this like girl who's several years older than us in our cabin. And again, there's several families that brought this case. So lots of different instances where because the school defines sex on its kind of the way that it segregates kids during overnight trips, it defines sex based on a child's self-avowed gender identity. So boys can sleep wherever they want and girls can sleep wherever they want as long as they say that they're the other thing. So legally, in order to protect their kids and to raise them in accordance with their religious beliefs, these parents sued the Colorado School District over their policy. Really, they're asking for exemptions from this policy. They didn't even actually ask them to change the policy, but just to give them the opportunity to say, I don't want my kids sleeping in the same bed as a member of the opposite sex. And at the trial court level, a judge actually dismissed their claims with prejudice for lacking standing, which if you want to kind of see an opinion that you'll scratch your head over a little bit, I would encourage you to read that. But very recently, they argued their case at the 10th Circuit on appeal. And there are two main claims here. The first is a little bit more straightforward. It's that substantive due process line of cases from the 1920s, which we've had for over a century, that says that parents have a constitutional right to direct the upbringing of their children. And then this is a clear instance in which a parent is trying to say, I don't want my kid being forced to sleep in a bed with a member of the opposite sex. That should be protected under this theory. And then the second, and I want to spend a brief moment on this, is that more recently the court has expanded protections for religious parents when a public school district imposes an ideology that violates their religious beliefs. You can think of Mahmoud from last year, where Montgomery County Public Schools revoked the parental opt-out when they made kids sit through pro-LGBT storybooks and that sort of thing. The court ruled in favor of the religious parents there. And more recently in Mirabelli on the emergency docket, that was the case where the court ruled against California's parental exclusion policy. Basically, the California public school districts were told that if a parent objected to a student's gender transition, staff should lie to the parents, deceive them about anything going on, and basically ignore whatever they tell them. Now, what Mirabelli did that was really important, among many other things that was very important to Mirabelli, but part of what it did was it took the legal reasoning from Mahmoud and applied it in a new context. Now, Mahmoud basically skipped the Smith framework. Now, Smith says that, again, most of our listeners are probably familiar with this, but Smith says that if there is a law that violates free exercise, it only is subject to strict scrutiny if it is neither neutral nor generally applicable. Basically, in effect, this means that if a law doesn't target religion on its face, odds are a plaintiff bringing a claim against it isn't going to win because it's never going to reach strict scrutiny. Now, in Mahmoud, the court said that because of the type of right being implicated here, this parental free exercise right, we're going to skip the whole Smith analysis and just go straight to strict scrutiny. And then Mirabelli reaffirmed that and brought it into a new context and said Mahmoud wasn't just about coercive curricular requirements. In fact, the religious infringement on their rights in Mirabelli was greater than that in Mahmoud. Um, so I think myself and many others are kind of hoping for the next case in this line of cases that takes Mahmoud and applies it in a greater context. I don't think this will be it. That's not really the argument that's being made because this case was briefed before either of them came out. Um, but this kind of case, if it goes up to the Supreme Court or kind of other cases that look like it, could be the vehicle to take that logic from Mahmoud and apply it in an additional context, even beyond Mirabelli. Um, so that's kind of legally what's going on here. The substantive due process claim will have to be heard um, on appeal after they actually get to the standing questions, and then hopefully this case or one like it, as it continues to go up, will be that next step in that Mahmoud Mirabelli line of cases. And I want to close with this. At the end of the day, though, the most important thing in this case is that these kids are not forced to change, sleep, and shower in front of members of the opposite sex. The stories from this case are insane. The young boys in this cabin had an 18-year-old girl who was several years older than them in their cabin, and many of them were afraid to change, and many of them just didn't shower because they didn't want to. They were embarrassed or afraid to do it in front of her. If nothing else, just the awkwardness of knowing that you have to do that in front of somebody who's a member of the other sex, and these are young kids. Elementary and middle school age kids, girls and boys, are being forced to sleep in beds with members of the opposite sex. It's not a straw man argument. This is actually what's happening, and it's happening in this case. That's entirely unacceptable. Schools have a serious moral obligation to take good care of the children entrusted to them. This is all the more true for public schools, especially because parents are required to send their kids to school, and many don't have the financial resources to do anything other than public school. So a lot of times parents are forced to put their kids into a public school, and those schools have a very deep and serious moral obligation to, at the very least, not do the exact thing that parents tell them not to do. And what we're seeing here in Colorado is a deeply disordered failure and violation of the trust that parents are often required to put in school staff.
All right. Well, I'm not going to comment on the legal posture. Your analysis is good. It's we're in insane territory, and I guess the one thing I would just say is just to confirm what you're saying, that the parental rights arguments are necessary, and to the extent that we can strengthen them through continued case law, that's great. But that is an insufficient response to these problems, because the common good requires not that parents have the right to opt their little girls out of being in the same bed with a boy, but that there should be no situation in which little girls are being put in the same bed with a little boy, period, regardless of what a parent's opinion on transgenderism or their kid's safety is. This is just objectively unacceptable, right? So I'll say this because you covered that well. I just want to make a philosophical point here. So I was listening to something interesting maybe a month ago. The noted kind of right of center writer, thinker Mary Harrington has been really interesting on opposing transgenderism and like modern versions of feminism and stuff. And she's a really interesting writer, but she has historically not relied on Christian arguments or understandings of the world to make her cases. And she gave a lecture that I recommend to anyone listening to this at First Things a couple months ago called Tomophobia, as in phobia of St. Thomas Aquinas, right? Very clever. But it was fascinating because what she said is she's been grappling for a long time with something's wrong, right? With this modern understanding, obviously, of like, what is a woman? What is a man? What is a mother? Like, we can't make sense of any of this. And even critics of modern feminism and modern gender theory are kind of including herself, like, are struggling to figure out how do we root this? Like, what are we saying, right? What is a boy? What is a girl? What makes a woman able to be a mother and a man not? Right? Like, we can point to physical organs, sex organs, and things like that, but ultimately, we're not getting at the point because you have issues with that. Like, what if a woman is sterile? What if she's born without certain organs and she not a woman? And it was fascinating to watch Mary Harrington, who I very intentionally had not spoken on Christian grounds for years, saying that it dawned on her recently that until we go back to Aristotelian and Thomistic concepts of reality, we're actually not going to solve these problems. And you see it in the modern, like, conservative movement. There's a huge opposition to these things because it's intuitively common sense, right? That boys and girls are different, that boys shouldn't be sleeping in beds with little girls and shouldn't be in the same showers because just whatever you identify as, boys and girls are different. But it's very hard to articulate how that is and how that holds without um Thomism. So I think it's an interesting thing for everyone to reflect on, to get a little bit nerdy as we wrap up here. But basically, the modern error started in the last, I don't know, 3 centuries. You probably identified around the time of, like, Francis Bacon, where there was an intentional desired or attempt, and it succeeded, to get out of science and really most public discussions formal causality and final causality. And I won't go into too much detail. I think most of our listeners are probably somewhat familiar with this. If you're not, you should know what the four causes are. They're incredibly important to understanding what things are and what they're for. But the basic idea, right? The efficient cause, what made it or who made it. The material cause is what is it made of, right? The stuff of it. The formal cause is what it is in its essence. And the final cause, or the purpose, right, is what is it made for. And modern thinking over now a long time, several centuries, has tried to look at the world and understand the world based only on what made the thing and what is it made of. But if we don't accept that things are something in their essence, something unchangeable, something immutable. In our case, man and woman is part of what you are in your formal causality, in your essence, and what you're made for, right? Men and women, persons, we are made for specific things. If we jettison those and we kind of talk on materialist grounds, as if there's no life doesn't have a purpose, man doesn't have a purpose, woman doesn't have a purpose. We're just made of stuff and we're here and that's it. We're never actually going to solve these problems of what is a boy, what is a girl, how do we do all these, how do we deal with these trans issues, how do we deal with the differences between the sexes. Um, so I know it's like a very trad thing to say we need to go back to St. Thomas Aquinas, but I think it's largely true that a lot of the modern conversations are not getting to the depth of what's necessary to really resolve these. Like you said, parental rights is a good backstop to keep, religious and sane people, to keep their kids safe. But ultimately, I think we need to go deeper and actually understand what we are as humans and what we are for if we're actually going to push back. Otherwise, I'm not that hopeful that we can really have coherent answers to the problems that ail us.
Yeah, absolutely. I couldn't be happier that my last episode closed with a little dive into parental rights and Aristotelian metaphysics as the solution to the ails of our current day. So
I think that's a good way to wrap it then. So with that, again, thank you, Joseph, for your year and 8 months here at Napa Legal, and then about a year on the podcast, I think. Really grateful to have you. Sorry, I'm coming off of a a cold here. And with that, um, thank you to our listeners. We hope you'll join us next week. We'll probably have some guest hosts in the interim as we try to find a replacement for Joseph, which is going to be a tough thing to do. So we hope you'll join us next week as we continue to highlight and discuss the most important ongoing legal issues that affect religious liberty and the work of faith based nonprofit organizations. With that, we'll talk to you next week. Thank you for joining us, and God bless you.